us. We have an exciting session for today. We're going to be discussing something that's quite topical right now and pretty relevant in the digital asset space, which is bankruptcy, insolvency, and restructuring considerations. I'm joined by Sam Gabor, who is counsel in Gowling's Calgary office. He has a long-standing litigation practice focused on restructuring, insolvency, and bankruptcy law, and acts on behalf of companies, borrowers, lenders, receivers, trustees, and lending restructuring scenarios. He's also written publications on digital assets, the metaverse, NFTs, DAOs, and has consulted with the government of Alberta regarding Alberta's Personal Property Security Act to specifically incorporate a framework for digital assets. Sam, thanks for joining us.
Thanks for having me.
Yeah. And I'm also joined by Tamie Dolny, who's an insolvency litigator at Berlis, with an extensive experience working on Canada's largest crypto asset files. She's previously acted on behalf of court-appointed representatives in the pretty well-known Quadriga case we'll be touching on, and has wrote to the RCMP to advocate for the exhumation. Did I say that right, Tamie?
Yeah, you nailed it. You nailed it.
Thank you. I tried. Exhumation of Gerald Cotton, who is the CEO and founder of Quadriga, and has also acted as a member of the Canadian Insolvency Council team to the ad hoc committee of equity interest holders in the ongoing Voyager proceedings. You'll have to translate that one for me at some point, Tamie. Thanks for joining. And I am Pouya. My practice, I'm a lawyer at Renno and Co. My practice involves helping blockchain and fintech companies navigate their way through the complex web of Canadian securities and AML regulations. I support, from supporting regulated companies stay compliant to helping companies kind of modify and restructure their business in order to reduce regulatory burden. Those are some of the things I do. I advise crypto investment funds, crypto trading platforms, payment service providers, a whole bunch of other lovely folks in the space. And I also am an adjunct prof at George Brown, teaching a blockchain law class, and will be teaching a blockchain risk management course at the Toronto Metropolitan University. Hope that intro is not too long. Let's kick things off. Sorry there, one sec, my computer just froze. All right. So there's been a string of highly publicized bankruptcies and insolvencies in the crypto space in the past year, which I think is like one of the reasons why we're kicking off this year's legal discussion on this topic, and super key right now as we're going through what people would call crypto winter. We've had the Terra Luna collapse. We've dealt with Voyager, Celsius, FTX, Genesis, and then on the mining side, folks like Salvius Mining. Could you give us a quick rundown of how we got here?
Sure, yeah. Thanks, Pouya. So I think the crypto space has definitely been building up since Bitcoin launched over the last decade, but particularly with COVID, everything really changed. During COVID, governments around the world put in massive amounts of liquid capital into the markets through different types of injections into companies. And at the same time, we had zero interest rates as well. So there was just an abundance of money going into the system, which allowed huge levels of borrowing huge levels of venture capital funding, equity funding, and the creation of new crypto projects. And with that, along with every other sort of market in the world, we got hit with inflationary issues. Really, in my view, the problems we're seeing really started in June 2022, when the US federal government started signaling they were going to raise interest rates, and all the world governments started signaling they're going to raise interest rates to try to get inflation under control. And really what happened after that was there was a huge start of a sell-off through the tech market, and really crypto kind of got tied into that tech market space. And then when that started, we started seeing different crypto events happening. So the first, really, in my view, that set it off was when Terra Luna depegged and collapsed. That caused Three Arrows Capital to start suffering significant financial distress due to its exposure to Terra Luna. And then when Three Arrows Capital failed, Voyager Digital and Celsius, the exchanges, started suffering significant financial distress and withdrawals from their systems by customers due to their exposure to Three Arrows for the loans that they were subject to. And when that sort of first cycle happened, we started seeing Bitcoin drastically declining in price. And then the result of that was Bitcoin miners now started feeling the squeeze because the price of Bitcoin is going down. And at the same time, we have world economic events happening with Ukraine and Russia and the price of energy spiking. So the price of Bitcoin declines, the price of energy goes up, and the Bitcoin miners now start feeling the squeeze. That was sort of the first triggering event where we started seeing larger insolvency events happening. The second was that really have put us into the current place that we are now, is when FTX went under. It really started with the series of tweets between CZ and Sam Bankman-Fried, and then everyone. I'm not going to go into the history of sort of how FTX collapsed, but once FTX started collapsing, we saw Bitcoin drop to its current lows of 17,000 US. We're now seeing it go back up. It's gone up thousands of dollars over the last couple months. But during that time, we also saw massive mining players in the US go under and have to file for Chapter 11 bankruptcy protection to try to restructure their businesses. So we saw Compute North have to file for Chapter 11. Celsius Mining with the Celsius filing prior to then was in Chapter 11, and Core Scientific is in Chapter 11. They're some of the largest mining players in the field. And then at the same time, prior to then, we had Voyager Digital filed for Chapter 11, and in Canada, they filed what's called a CCAA recognition proceeding in Canada, which Tamie's actually working on with her firm, acting for unsecured creditors on that file. Celsius filed for Chapter 11, and everyone has read about FTX. There's very interesting insolvency issues out of FTX that we could talk about for probably hours. So there's been very large players in the US going into Chapter 11. There's been other exchanges in Australia and the UK that have also gone into creditor protection. And that's sort of a big picture of where it started, I think, last June 2022 and where we are today. And the big picture, which I've sort of taken from the crypto space from an insolvency perspective, that it's really a self-contained ecosystem where when you have a insolvency event like Terra Luna going down, it can trigger all these other events and create market distress throughout the entire market where everyone feels the squeeze. You don't just have one particular industry. So you have exchanges going down, you have lenders being impacted because they're not getting repaid. Miners are getting impacted because the price of Bitcoin goes down. Added that with global events that are happening with prices of energy, consumer confidence, inflation, or whatnot, you can really get a massive insolvency event across the field. So that's kind of where where we've gone to, in my view, sort of big picture.
That makes a lot of sense, Sam. And I guess like the one thing I took away from what you're saying is the high level of like interconnectedness between different players in the space. And I think that makes sense and is like is consistent with like the kind of like ups and downs the general crypto market seems to have. So yeah, that makes a lot of sense to me. So Tamie, where do you think the space is heading from a bankruptcy perspective? Sam has kind of given us like a good like big picture view of how we got here. Like what's the direction we're going to?
Yeah, I think that's a great question. And Sam, I think that was a really good summary. And just one minor correction for Voyager, we're on for the equity holders for A and B.
Oh,
yeah. But it's all one and the same when you're kind of acting for creditors, but they all have kind of unique perspectives. But I thought one thing that Pouya pointed out about your answer, Sam, that was really interesting is really this concept of interoperability. And I think to answer your question, there are two, in my opinion, major insolvency concerns that are impacting the crypto market as a whole. So the first would be something that Sam really aptly touched on, which was interoperability. And the second is shadow banks, which I'll go to second. But I'm a firm believer in aspects of the crypto industry and the need for stability and its growth. I'm really excited by it. But saying this, we know that blockchain interoperability at this point is very limited. And this is likely going to trigger further insolvency concerns if the crypto community doesn't address this. And what I'm really referring to is the ability of blockchains to interact with one another. So a lot of what we're seeing in the industry right now is we have these very isolated chains that have no connection between each other. So in an ideal growth, as the industry gets larger, we would have much more cross-chain decentralized exchanges, even cross-chain NFT projects. So generally speaking, these are termed as modularized applications. So without this, insolvency concerns for the market pop up, and which is exactly what Sam highlighted in his answer. So stable coins, as an example, there's very weak stablecoin interoperability in the market as a whole. So what that means is that a run-on-one can trigger the collapse of these entire fragmented systems. So the issue of this is, for instance, you can't use USD coin on certain, like on Ethereum, to pay for something on another blockchain. And so what we're looking at right now in the existing crypto framework is we have a small number of dominant blockchains, and we also have projects that are connected to exit nodes. So for instance, there are explicit pairings often between crypto exchanges and stablecoin issuers. And what Sam really summarized is sometimes when one project falls, that also can cause the collapse of an exit node itself, which is a really big issue. So solutions to this interoperability concern is for the industry to really begin to develop more cross-chain interactions. So I'm an insolvency lawyer. I'm not a tech person, but I understand that there are a lot of growing solutions to these issues. So examples that I've read about are token bridges, token swaps, and contract calls. Now, the downside, obviously, of more cross-chain interactions is there's, as a result, an increased number of hacks sometimes. So I think it was Chainlink who pointed out in one of their reports that over, I think, 2 billion USD in assets in 2022 were stolen in hacks by attackers from DeFi platforms. So as we develop the growth of these cross-chain protocols and interoperability frameworks, we also need to make sure that we keep security hacks and security at the top of our mind. The second issue, as I see it as being the biggest insolvency concern that the market faces, is the use of shadow banks. So it's a question of the relationship between the bigger exchanges, payment processors, and offshore shadow banks or even hedge funds. I can give you an explicit example. So we knew in Quadriga that Crypto Capital, who was functioning as their shadow bank, allegedly, Crypto Capital Corp, which eventually got, there was a huge US drive to prosecute it through Reginald Fowler.
Tamie, just one quick question for folks who don't know. Could you give a quick rundown of what a shadow bank is?
Sure. So a shadow bank is a loose term for it could be a bank, it could be a payment processor, it could be a hedge fund that often operates offshore and supports exit nodes or crypto asset platforms with their liquidity concerns. But a huge issue with these shadow banks is, for obvious reasons, if you are a bank that is operating outside of North American or European compliance regulatory frameworks, it's much easier for you to lend money without, Pouya, you see this all the time in your practice, the heavy amount of regulations and compliance that, for instance, Canadian companies have to go through. You're not going to have to go through that. Yeah, and so these shadow banks, the issue is that when you only have a couple of these massive shadow banks, they control the liquidity of these exit nodes. And what I was saying before is in Quadriga, we had Crypto Capital in 2017, who was allegedly providing shadow banking arrangements to not only Quadriga, but also BitMEX, Bitfinex, and even allegedly Kraken from some of the online information that was circulating. So the outsourcing of control of crypto to these shadow banks or trust companies that underpin or control a lot of the collateral is, from an insolvency lawyer's perspective, quite dangerous for the industry and the market as a whole. And I think something that's so interesting is I always wondered, right, before Celsius collapsed, how were they offering these crazy high interest loans, right? How were they offering, for instance, 18% payments for deposits? And when you study how these exchanges and these exit nodes were actually operating, it gives you a lot of insight into solvency concerns of the market in general. So returns were so high during the bull market because non-bank crypto entities would lend out actual crypto to these hedge funds or these shadow banks. And then what these shadow banks or these hedge funds would do is they would trade, right? So they would take this crypto and they would do these insane trades between spot price differentials versus derivative contracts. And so, for instance, as a result, a hedge fund could buy crypto or receive it as in a lending arrangement with one of these crypto exchanges. They could sell futures and they could profit at these crazy spreads during a bull market. Now, obviously, when the bear market starts to hit, you aren't seeing these massive gains, and as a result, these high interest payments of 18% that were offered by Celsius just really fundamentally aren't sustainable anymore. So to kind of summarize that answer, which I recognize was fairly complex, is there's interoperability and there are shadow banking concerns. Both are tied into each other. And until really the market begins to address both of those issues, I think we're still going to see a lot of solvency issues. And really a perfect example of this is what came out even today on CoinDesk, right? Which is that with Binance, $1.8 billion in USD coin potentially can't be tracked, and also might have been directed to Alameda, who, as most people who are listening to this are aware, was a significant cross-party in the ongoing Voyager and FTX insolvencies. So crypto, in my opinion, I love the crypto community. I think it's fascinating. But as soon as you have solvency concerns that the exit nodes are challenged by, that's the main issue. And the industry really needs to stabilize those relationships in order to avoid these crises that have happened.
Okay, got it. I think one thing I'm like gathering from this, and just for a little bit of context, I know little about the bankruptcy space, so I'm like in the same boat as a lot of folks tuning in. So it's like I'm having a difficult time wrapping my head around it. But one thing I think I am like gathering from this is like there's these like what seems like pretty high risk, high reward transactions and like kind of like financial instruments, like interconnected players, a lot of which are operating in low regulated jurisdictions. 100%. And these things work and things are going great and everyone's making money when there's a bull run. but as soon as there's the economic downturn, it's like completely unsustainable. And then when one of them goes down, it's kind of like a domino effect and everybody else kind of goes down with it.
Yeah.
Does that kind of capture it?
Yeah, and I think
Probably like very simplified.
I think so, and I mean I think a big thing now we're seeing right now is consumer confidence really playing a huge part of where the market is. You know, after June 2022, it really seems like there's a lot of caution now before doing any trading and doing any sort of massive investment, just because there are so many uncertainties in the marketplace. I mean, I think for the most part, a lot of the big players now in the United States have really been hit. They're in Chapter 11 restructuring proceedings now. They're going to try to restructure the business. I mean, the interesting thing with crypto is that there's an ability to actually come up with plans and repay creditors in crypto that would not have necessarily existed in the traditional financial space. I know there was a restructuring in Australia that just happened where they've essentially made all the deposit holders whole by issuing new crypto tokens and restructuring the business that way. So it does make it very interesting from that perspective, and from a restructuring perspective, what you can do, because you can create, if you have confidence in consumers that want to stay in the crypto space, you can start issuing new tokens, and so long as it's regulated and you meet the rules, and you know stakeholders aren't being prejudiced. You know, if deposit holders want to be paid back in crypto, they're entitled to. So it does create a lot of flexibility from a debtor perspective. And I mean, in my view, I think that the big players have really been hit, but I think the medium to small players are now feeling the aftershocks in the marketplace because of the consumer confidence. You're seeing companies starting to pull back on certain deals. I know Visa and MasterCard had really entered into the space to allow retailers to take, to allow users to use their crypto and it converted to fiat. And now they're sort of withdrawing from certain contracts and third parties. So I think you're seeing space there. I think you're seeing space from the crypto mining perspective in Canada, in particular. British Columbia, Manitoba, and Quebec have all put moratoriums on new mining projects, and in New York City, in the state of New York, they're doing that as well too. And I can see governments who just don't understand how mining works and the benefits that it can provide to provide energy into the market are going to potentially try to continue squeezing that. So I think the mining space is going to be having challenges that they're going to have to think about. And then I think, Pouya, maybe you want to talk about this from the regulatory concern. I think this is one of the biggest challenges now, is what do companies do from a regulatory perspective, because there is so much uncertainty, and how do they operate in a way that they protect their solvency and they can continue operating, because they don't necessarily know what decisions to make, because governments really haven't made up their mind how they should be acting.
Yeah, it's a really good question, Sam. I think like the regulatory burden on a lot of players in the crypto space has pretty dramatically increased in Canada over the past couple of years. Notably, a few years ago, securities regulators in Canada, the CSA, took this novel position that a cryptocurrency exchange that is holding crypto assets on behalf of their clients. So just kind of like a custodial exchange, we could think of a whole bunch like Binance, Coinbase, in the Canadian context, CoinSquare, Wealthsimple. So they took the position that like, if you're holding crypto on behalf of your clients, even if the underlying crypto isn't a security, that relationship that you put together as a result of the custody, that constitutes a security itself. And what the consequence of that is that all of these custodial exchanges now have to become registered as dealers in Canada. And from like a financial perspective, like this is like a very, very onerous registration and regulatory requirements. It's very expensive to get registered. It takes a long time to get registered. And then once you are registered, there's a host of ongoing obligations. Practically speaking, like I think like that has the effect of squeezing out a lot of like players in the space who just like don't have the funds to be able to compete. But it's interesting though, this is I think like one of the ways in which kind of like Canadian securities regulations and bankruptcy, insolvency, restructuring intermingle a little bit. I think one of the main reasons why securities regulators took that position, that like custody equals security position, to go full circle, had to do a lot with the fallout of Quadriga, which for folks that don't know, that there was a Canadian exchange a few years back. There was custodial, they mismanaged client funds, the CEO suddenly died, and then everybody realized, client funds, most of it or like a lot of it is in there. In a lot of ways, it's kind of like proto FTX. And in response, crypto regulators are like, or sorry, securities regulators are like, we really don't want that to happen again. And what that is a situation where you're giving your crypto to someone else to hold on to it for you, and then a whole bunch of shenanigans happens in the back end, and then all of a sudden you're just an unsecured creditor, and you thought it was your crypto. It's not really your crypto. In other words, a lot of the concerns were like classic bankruptcy considerations. What happens to you if the company goes bankrupt? What happens to you as like the user on the platform? And so yeah, I think that's the long-winded answer to your question, Sam. I think like the response has made it difficult for a lot of folks to compete, but I think from a bankruptcy perspective, a lot of it really is to protect Canadian investors against these types of like FTX situations, Quadriga situations from occurring. Does that make sense?
Yeah.
All right. So here's a question for both of you. I'll start with Sam. So I'm sure both of you guys have dealt with your share of non-crypto related insolvencies in the past. How would you say the kind of like traditional insolvency situations differ from what you've noticed working with clients in the crypto space?
Yeah. So, I mean, a traditional insolvency, like if you're going to have a sort of a receivership process where you've got a secured creditor stepping in, they have a receiver appointed who takes control of all the assets of the company. I mean, generally, there's a good idea of what the assets are, who the players are, how many unsecured creditors there are, generally based on a payroll list. If there's a building, you know where the building is. If there's equipment, you generally know where the equipment is. There is typically security interests that are registered in provincial registration systems. And with the crypto space, and if you have an insolvency, it really makes it much more challenging from a couple perspectives if you're an insolvency professional coming in. The first is, where are the assets? You could have assets move constantly and quickly throughout blockchain transactions on crypto exchanges. So it creates a lot of tracing questions in terms of recovering the assets. The number of creditors which exist can go from a couple hundred in a normal insolvency to what you're seeing in FTX and some of the other insolvencies to millions of creditors throughout the world. So you have jurisdictional issues. What I've noticed too is the professional costs are generally very high if you're going to have a robust insolvency proceeding in the crypto space, especially in sort of exchanges, because you need third parties such as blockchain tracers and other advice that just a trustee in bankruptcy or receiver wouldn't have off the top of their head. So they're having to spend a lot of money on disbursements just to trace assets and whatnot. Tamie wrote an excellent paper at the annual review Insolvency Law on tracing, and I'm sure she's got some comments about tracing, so I won't comment anymore on that. And then from the mining perspective, because of the ASICs equipment, it tends to be it's very specific equipment. It's used just for mining. So this is the mining concerns are similar to the concerns that have been apparent in the insolvency space for cannabis in Canada over the last few years, where you have very specific equipment that's created to create cannabis, and it can really only be sold to other cannabis producers, right? So you have these types of assets that really can only be sold in a mining insolvency to other miners, right? Because you can't, unless you're taking the ASICs equipment apart for parts, right, and repurposing it, you really can only provide it to other miners. So it does create challenges from a realization perspective for a trustee to like find other companies that do mining to buy the ASICs equipment. Now, you may have mining real estate where you can repurpose it for other types of businesses that do data processing and data centers, and AI and whatnot. But like from the ASICs perspective, where you could have that millions of dollars worth of ASICs equipment, like it creates realization challenges for sure. Where, if you have a normal building or a piece of equipment in a standard insolvency proceeding, if you got a tractor, if you're a farmer, you sell that off to another farm and they use the tractor for multiple purposes. So.
Okay, interesting. So here's actually a good question then on that point. So it seems like if you are a creditor in one of these, like let's just, for lack of a better phrase, like crypto context, in a lot of ways you're worse off than if you were in a traditional setting, just in that like there's so many additional considerations. A lot of the folks are offshore. You're probably paying more fees in order to manage everything. You're paying more for tracing. And then not to mention that, at least in like a mining context, like the equipment, like the assets that I imagine like you sell off, and then the proceeds from the assets like you get dispersed amongst the creditors. Like the assets have like a very illiquid market, and it's difficult to sell them because there's a very limited number of folks who would be willing to buy it. Is that fair to say?
Yeah, that's exactly it. If you're going to sell the business as a going concern, there's only certain types of players that can actually step in and buy that business, right? Know how to run it and be willing to buy it. And then at the same time, if you can't sell the business as a going concern, if you're going to sell just the assets, again, there's a limited amount of companies that would be able to come in and like buy assets on bulk, and that could be able to utilize them. So it does create realization challenges in an insolvency space.
Yeah, and I think to almost go off of it as well, creditors are always at a disadvantage as soon as you enter an insolvency process anyways, right? It's always a bad day when you go into an insolvency proceeding for a creditor. But when you look at the Canadian large-scale crypto asset insolvencies, so I'm thinking Quadriga, Einstein, Mt. Gox, Voyager is slightly different. And again, Voyager and Mt. Gox are foreign proceedings, but I'm just lumping them all together for the sake of it. But both Quadriga and Einstein, they weren't able to in any way emerge as going concern businesses, right? Which really speak to what Sam was talking about. And then from the creditor perspective on those files, and I would use the term creditor interchangeably with victims in some of these situations, is the fact that in the Canadian statutory regime that we have right now, I take the firm stance that inaction and corruption are synonyms. And I think that the regime within which we operate fails victims of white collar crimes, whether that be in the crypto space or not. And it bleeds back into what Sam was talking about regarding tracing, which I'm quite passionate about. in terms of advocating strongly for the need for statutory reform. I mean, we just saw in Quadriga, right? Money is still moving, and there have been no announcements of public prosecutions or arrests of the quote unquote bad guys who, whether or not you believe Gerald Cotton died or not, the other members who started to fund this exchange are still out there. And so what we're seeing is bankruptcy law on these files that move quickly. It needs to incorporate mechanisms, and you need to use professionals, whether that's court-appointed officers or lawyers or whoever it is, that are able to encourage coordinated responses to misconduct, because the police, as it stand in Canada at least, and I say this sharply, they don't do enough, right? And we see that in Quadriga, which is fundamentally a failure of the Canadian justice system. And so court-appointed officers who are fundamentally could be a trustee, could be a monitor, depends on the insolvency proceeding. But if you're trying to track or trace crypto, there are certain red flags that I think you should be aware of on these files, whether you're a creditor, whether you're a company that's engaged in trying to track back misconduct, whatever it might be. The first biggest flag, in my opinion, is who did you get the initial information and records from? Right. So if initial information that's provided to and relied on by professionals have been given to them by the bad guys, it's very difficult to recover on those funds. Right. The second biggest issue is their on the ground police involvement. And we've seen from Quadriga and Einstein that this rarely happens in Canada. Insolvency professionals such as myself or Sam are sometimes advocating on behalf of court appointed officers or representative counsel mandates, where professionals are given police investigation mandates without any government funding. And as a result, all of your tracing is coming from creditor estates. So at a certain point, are you going to use good money to go after bad? And it really is a cost benefit analysis that has to occur in every situation. So as insolvency professionals, as a lawyer in the space, one of the biggest tools that we have for going after the bad guys on these files is something called a Section 163 examination. It's an examination where we can investigate and ask questions about the estate, where money went to, where it might have not gone to. That's kind of our when you compare that in contrast to police powers on other files, really fundamentally what insolvency professionals are doing is sending out letters or sending out documents. But what happens when, quote unquote, the bad guys are overseas? What happens when the police aren't stepping up? What happens when there's no statutory coordination between court-appointed officers, lawyers like Sam, representative counsel? Is that often these files, the recovery rates are so low, and it's very disappointing. But that being said, I don't think that it's impossible to recover. But in order to recover crypto assets, and there have been successful recovery cases, is you need an existing pool of good money to go after the bad, right? You need some type of litigation funding, which is always a third-party litigation funder could step in. It could be a creditor with a significant asset class. But until you have that existing amount of money to pay professionals, I think estates and lawyers that represent estates should be really cautious about using limited estate funds to go after quote unquote bad money. But that would be my recommendation for that tracing issue.
Yeah, that's I totally agree, Tamie, what you're saying. Like the crypto space is so different from other types of traditional insolvencies in Canada because you really do need to be fast. You need to have incredible speed as an insolvency professional to try to recover assets. And that requires cooperation overseas where crypto could end up in a different exchange. And you need to be able to move quickly if it's ever converted into fiat. And it's incredibly costly. Like I believe it was in Einstein where they appointed Grant Thornton as the interim receiver, and they were only in as the court-appointed interim receiver for 2 weeks because they did their investigation and they only saw there was about $60,000 of assets, and that was nowhere near enough money to go after the assets that have disappeared. So really, yeah, you have to have a strong amount of money to be able to do a high profile crypto insolvency. And if the money disappears, then there's no funding. That's really unfortunate, but the deposit holders are just going to lose all their funds.
Yeah, and the thing that's I would argue even like the bigger issue is the fact that we're fairly lenient on the prosecution of white collar crime in Canada generally. We have something called the deferred prosecution system in Canada, which depending on who you act for, you might have different feelings on. If you're acting like me on some files as representative counsel for victims, there are very few cases in Canada, right, where parties have been held liable or criminally prosecuted on white collar crimes in general. And it points to something, which is that on crypto asset tracing files, it's even more rare to see it happen. That doesn't mean that it isn't possible, but it means that companies that are restructuring should really emphasize a creditor-driven restructuring, right? And so it's all about the messaging when you're going through an insolvency process, because once you get the creditors on board and once you're able to share and to show to the public that misconduct isn't the concern, but the actual concern is maybe economic, you can be really successful in moving forward as a going concern business based off of all the considerations that you were outlining before, Sam. But again, I really think it's about tailoring the messaging, and it's also recognizing if you are a creditor going after funds that have been misappropriated through the crypto community, whether in a mixer or wherever they've ended up. Fraudulent actions, it's difficult to go after them in Canada, and the professionals who work on these files really have to tailor their responses in litigation to the crypto community as a whole. And again, that's a very different value add than on traditional files that we see in the insolvency space.
Yeah.
One thing I'm actually a little bit curious about is so Tam, you initially said that it's very difficult getting police cooperation, and that part is a little, for me, hard to believe. And I guess it kind of ties into the next thing you said about how difficult it is prosecuting white collar crimes, because a lot of these, especially in the crypto space, you're thinking Quadriga or FTX, it's not just a bankruptcy. What preceded the bankruptcy was criminal activity.
100%.
It's surprising to me that there isn't effective criminal prosecution taking place alongside the bankruptcy. Why is that?
Yeah, I mean, I think it's the statutes, right? So there's no mechanism by which insolvency professionals can compel police action. So you look at Quadriga, right, where we wrote a letter basically asking the police to act, right? Whether that be just simply doing a double check of what happened.
Why don't they?
I mean, the reason why they don't is because there's no accountability, right? There's no reason for them to, because there's no mechanism in the law by which we can compel their involvement, right? The police are operating in a completely separate sphere. I could talk about that for hours, about all of my issues with that. But it's frankly disappointing. And especially when you see so many insolvencies are either because of economic reasons or crime, right? It's one or the other. And I sometimes find that when they're streamlined through the same system, it's a disadvantage for both the estate and creditors. But in order for that to be rectified, to be really rectified, right? Because think about Quadriga, right? Even this went back to what you were saying before, Pouya. Quadriga was emerged in a system where Canada was aware of its regulatory failures for years. There had been multiple different comments made by international bodies that Canada did not have an appropriate crypto compliance system. After Quadriga, the system swings to become some would say almost over-regulated, right? And until we have kind of a mechanism by which we not only criticize crypto companies, because crypto companies, the vast majority of them aren't the issue. The issue is the police, right? The issue is investigating crimes. And until we have a system by which we are able to actually prosecute these crimes, we need that pendulum to move back and the appropriate parties to be held accountable.
The only last comment I would have, just to add to Tammie's, I do, in my experience, doing litigation files and insolvency, it really comes down to a resource issue as well.
Yeah.
Like the police just don't have the resources. And anytime there's any sort of white collar crime, criminal, arguably criminal fraud, the police, in my experience, has said, look, this is a civil matter. You have the ability to deal with it through the courts. If you really want to, as an individual, you can bring a prosecution of a criminal proceeding yourself. The Crown always has the right to take it over at any time, but you could spend the money doing that yourself. So I really think it comes down to a resource issue, and crypto is not a high priority for police. It's not until you get high profile events like FTX where you have so much public outcry that the police have to step in and deal with it that these events happen. But on an individual basis where you have a small group of people or even a couple thousand, we're all losing some money, the police, in my experience, in my view, they don't look at it as being a high priority issue.
Yeah, I think it goes back to the need for statutory reform personally, but I could talk about that for days.
I think, thank you guys. That's really interesting knowing, and like all very like new information for me personally. Just like not understanding, like I just assumed that there was a level of coordination taking place between these like different government entities here, and it sounds like to the extent that there is, it's maybe not enough. All right, so I'm going to quickly pivot, being mindful of time, to a question that's a little bit more like practically oriented to actual players in the space and who are maybe like considering restructuring as a potential option. So Sam, I'll start with you. So are a Canadian crypto company having trouble paying back creditors? What are your options and key considerations for determining next steps?
Sure, that's great. And I think it's important to, in the crypto space at least, to delineate between creditors and your lenders, because you could be a creditor just putting money into an exchange versus someone that's actually lending you money to run your business. So I'm going to talk more on the lending side. This is applicable for any type of business, that you should take certain steps if you are having some distress in your business and you're starting to deal with your lenders. And I'll talk about first sort of what you can do to work with your lenders, and the second is some out-of-court approaches that you can take if you're having some financial difficulties. The first is, and I work with lots of lenders as clients, and there are certain things that they are looking to have happen that will give them comfort in the lending relationship if you're having trouble. The very first thing is get good professional advice. Get a good lawyer who understands insolvency, who understands debtor-creditor relationships. That will go a long way to building the relationship and a level of trust with your lender counterpart, to give them the time, to have them give you the time that you need to try to deal with the financial issues that you're having, because it shows that you're making an effort and you're getting good advice from them, and you're not just going to go and take steps that may not be appropriate in the circumstances. So that's the first thing, is get a lawyer who knows what they're talking about. If you need a financial advisor, there are different accounting firms that can provide financial advice in terms of restructuring. Make sure you've got a good accountant. Make sure your financial systems are up to date and you've got good financial information that you can provide to the lender. That's very important. The second is provide good, timely reporting to the lender so that they are they have the knowledge and the information that they need to make decisions. There's nothing more that lenders hate more than anything is when they're kept in the dark. If you are a borrower and you keep your lender in the dark and they have no idea what's going on, and you're not communicating with them, it shows that you're not serious about the financial difficulties that you're having, and it creates a lot of concern on their end in terms of what is going to happen with their collateral, because most lenders will take security in whatever assets that the borrower has, whether it's crypto or a property where you're doing a mining rig or the mining equipment. They need to have good reporting. The third is that if you're in financial distress and you're working with your lender, is to come up with a good concrete plan about how you're going to fix your problems that has good milestones, because the lender is going to want to say, or going to want to see that, okay, in a month you're going to do this, and the next month you're going to do this, and the next month you're going to do this. You know, you may be in a situation you got to sell your whole business, right? So it could be, okay, in 30 days you're going to hire a professional to help you sell the business. 30 days from that, it's going to be fully marketed. The next 30 days you're going to start getting letters of interest or, you know, informal expressions of intent. The next 30 days you're getting letters of intent, and the next 30 days you're getting a formal offer to sell your business for somebody. So create a plan that shows the lender you're going to be able to deal with the situation and pay them back. If you get to the point where they're telling you have to pay us back our money. And the last big level point is, don't just go back to the lender asking for more money to solve the problem. That is sometimes available in certain circumstances, but if you've reached a point where you've had such financial difficulty and the lenders have expressed to you that you need to create a plan to deal with the problem, don't just go back to them saying, oh, I need more money. If you give me more money, I'll be able to deal with it. They're not going to want to hear that. So have concrete plans to actually get the lender paid or to properly restructure. And now some approaches you can take that are available in the crypto space or the traditional space would be try to restructure your debt obligations with the lender. So let's say if you're supposed to pay back the money that you've been lent over, you know, a 2-year period, try to restructure that, push it over for 3 years. Cutting expenses. So if you've got to cut down on staff, that's happening a lot now in all the tech spaces. Everyone's cutting down staff to try to save on costs because the tech market has declined and stock prices have gone down, so everyone's cutting staff. If you're in real trouble and you basically been told by the lender, you got to pay us back all of our money, you can consider selling some assets or even selling off your whole business, try to pay them back. Third is what's happening now with certain exchanges is they're considering amalgamating so that they can find synergies between each other and create efficiencies, cut off any excess. That's another option. And finally, find new equity, right? Find new capital, shareholder injection, pay back the lender that way. Banks love it when you get new capital put in to pay down the loan. So that's another option. Those are all sort of approaches that a borrower can take who's in some financial trouble. From a traditional sense, and you could use those in the crypto space too.
Yeah, I think one thing that Sam, you highlighted really well is there just has to be a plan of attack that's really fundamentally customer centric, right? And in all of those ideas that you're putting forward. And I think especially with out of court refinancing options in general, the goal is always to avoid an insolvency process until you really have to enter it because of the costs that are involved. And so other kind of refinancing options at large that are available to crypto companies, I would identify 3 more on top of the great list that you already compiled, which is first, again, you can go to, it's very difficult, we know, for crypto companies to get loans from banks, right? Most crypto companies are struggling intensely with banking relationships.
Even
right?
just get a bank account.
Yeah, it's like it's impossible, right? In a lot of the cases, especially in Canada, right? Again, I'm not talking, and this is why shadow banks come up. But again, so an option is always non-traditional decentralized loans if you are in possession of existing crypto. The second, which Sam, you pointed out before with in your discussion earlier about launching their own tokens as an alternate form of raising additional cash. And then the third is also, again, just generally loans to crypto counterparties in the space, which comes at a risk, like, right? Like we see Alameda and how interconnected it was between the crypto winter that's happening right now in America. And so there are always insolvency consequences to these things. But even so, there are a lot of there's something that's coming up more and more that I'm seeing in news articles, which is something called refi, right? So regenerative financing generally in the crypto space. So this can span distressed financing transactions for climate companies, even to just refinancing over homes. So we know, for instance, that there are even new crypto mortgage offerings that are coming up nowadays, right? Where borrowers can actually access, and it's largely in the US, but access US dollars by pledging their crypto assets and property to cash out up to 100% of their property's home equity value, right? So there are these really interesting new projects that are developing. But one thing that I would note is that one thing to consider when you're refinancing your company is, are you exposing yourself to even more risk, right? Are you triggering insolvency concerns above and beyond what you had earlier? So we know, and we see in the States right now, there are, with the incoming UCC Article 12 and related amendments. So cryptocurrencies nowadays, under these amendments, there's a new Article 12 that governs the transfer of property rights and a new class of digital assets called CERs, or controllable electronic records, has been created. So to translate that from lawyer talk, which I realize is very heavy, is there are increasing ways in which we can register security interests in crypto. And I raise this because if a crypto company is using a creative new way to refinance their business, they always need to be sure that their security interests are protected, especially if they hold crypto either cross-jurisdictionally or in trust companies in different jurisdictions, whatever it might be. But I, as a lawyer, I'm often skeptical about the need for security interests if you control the crypto yourself. But if, for instance, as a company, you are lending out your crypto, or you no longer hold that existing collateral, you have to be really careful. And at that point, when you are giving, again, it's a common sentiment in our space, right? If you don't hold that crypto, you are not in control of it. And so sometimes if you are entering into these agreements with counterparties and the counterparty isn't appropriately reporting their insolvency to you, it's really important for you to have trusted legal advisors, or whoever it might be, who are always registering security interests appropriately. So again, I advocate for refinancing out of insolvency processes, but at the same time, crypto lenders who are facing these insolvency concerns, you always should consult a legal advisor, a lawyer, whatever it might be, before you refinance, and especially before you spread your existing crypto between jurisdictions and between parties who may have their own solvency concerns. I think that's a really big flag when you're looking at these refinancing options.
Yeah,
that makes a lot of
absolutely, Tamie. And I've done a lot of reading on the amendments to the UCC, and that was what I was in discussion with the Alberta government. Because in Canada right now, we have no regime or sections under what's called our personal property security legislation that deals with cryptocurrency. Everything falls under a broad category of intangible.
Yeah.
But there are a lot of gaps in the personal property security legislation in Canada for cryptocurrency, and in the US, and I think where Canada is going to follow suit is creating a system where, yeah, if you control the crypto, and they'll have tests for what determines control, and it's generally you're controlling the private key of a wallet as one of them, you will create a statutory scheme where you can take a security interest in it. You can register against the cryptocurrency. And I do think that's going to be very important from a commercial lending perspective for lenders in the traditional banking space who do want to get into cryptocurrency, and the current crypto lender space, that there needs to be statutory reform to personal property security legislation across Canada, the US, Europe, and have it sort of consistent across the world, so that you can register in jurisdictions where crypto can move very quickly and easily across jurisdictions. Otherwise, if you have this piecemeal system between different countries, it's going to make it very difficult. So more to follow on that, but I do think that's going to be very, very important. I think it's very good that you touched on that. One thing I think I should sort of touch to on is just processes that parties can take if you are at the point where you're insolvent. Like, what do I do? If generally the test for insolvency is if your liabilities are more than your assets, or you can't pay your obligations as they become due, which basically means you don't have any money to pay your creditors. Like you're not paying people out of the ordinary course of business. What do you do? There are two primary statutes in Canada which a company can look at if they're insolvent and they want to try to restructure the business. The first is the Bankruptcy and Insolvency Act. It has provisions in it which allow a borrower to obtain what's called a stay of proceedings. It basically creates a moratorium on creditors from being able to enforce their rights against the borrower, and it creates an even playing field for all stakeholders so that the borrower can try to restructure. So how that's triggered is you file a document with an insolvency trustee in Canada. It's called a notice of intention to make a proposal, and it will create the stay of proceedings. It's a useful tool for borrowers or debtors to try to restructure. It's one thing about that process and that regime under the Bankruptcy and Insolvency, it's very statutory based. So it's very specific in terms of the timeframes that you need to hit to be able to restructure, but it does provide an avenue for borrowers to try to restructure their business and come up with a plan to try to pay their creditors. One thing that people should be mindful of that are considering this is that if you don't file a proposal eventually under this system, you will be deemed bankrupt. So you have to be mindful of that before you go down that avenue. The second system is under what's called the Companies Creditors Arrangement Act. And under this system, you have to have at least $5 million of debt to be able to apply to get relief. So the amount of debt you have will really be determinative of your options of what statutory regime you can try to rely on. And on this system, you're relying much more on what's called the court's inherent jurisdiction, because the CCAA is supposed to be much more flexible in nature than the Bankruptcy and Insolvency Act proposal system. So the court has a lot of ability to make different types of orders depending on the circumstances. And Tamie right now is working on a CCAA with Voyager right now. So there's obviously more than $5 million of debt. And that's a cross-border recognition proceeding of the Chapter 11 in the US. So both systems are somewhat similar to the Chapter 11 proceedings in the United States. I'm sure everyone's heard Chapter 11 United States bankruptcy proceedings. And essentially, that's the US version of the Companies Creditors Arrangement Act, where businesses are trying to restructure their debt. And they're either using these systems to liquidate all their assets, sell off everything, or they're trying to sell their businesses as going concerns to some other purchaser. And then, or the third alternative is they are trying to restructure their businesses. So they're actually taking steps to cut costs, get new financing, sell assets to actually emerge from the restructuring as the same business. So there's options that are available. Those two are at an incredibly high level. Like Tamie and I could talk about the BIA and the CCAA probably for another hour, the different mechanics of it, but there are options available in Canada where if you have reached the point where your creditors are at the door, they're going to shut off power, you are in big trouble, you need some breathing room to allow you to restructure. These two are the ones you want to rely on. And if you're at that point, start talking to an insolvency lawyer. If you're in the crypto space, talk to someone who knows about crypto, because it is so industry specific that they need to have that knowledge to be able to actually go through a restructuring successfully.
All right. Thank you guys so much for your responses. I think we had a pretty good session. We We had an overview of kind of like some of the recent happenings in the crypto space from like a bankruptcy perspective, got some insight into where we're heading, had a really good discussion about, you know, maybe some of the potential shortcomings in the Canadian systems and some of the difficulties that folks are facing in order to recover assets, and had a little bit of a practical conversation about, you know, if you are in one of these potential insolvency situations, you know, what are some of the things you could do. Hope that was helpful for everybody tuning in. Yeah, thanks for tuning in.